founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on a bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website, and we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Our topic of the talk for today is Sharia estate planning, Wasiat and Hiba. My name is Marcus, and I'm an associate with Ma Wing Kwai and Associates, and I'll be your moderator for today's session. So before we start today's talk, let me introduce the firm and what we do. Ma Wing Kwai and Associates is a mid-sized law firm that was founded in 1985 by Datuk Ma. Our able team today comprises 22 lawyers and a support team of 19. Datuk Ma is today a consultant with the firm, following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with small, medium enterprises, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. We have ASEAN-China desk, construction, foreign direct investment, real estate, sports, and esports. Today's talk is part of our MWK online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with the COVID-19 lockdown, we would have to move our online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential client, and in-house counsel. Our recent MWK online talk was business continuity during COVID-19. The show must go on 8th of April 2020, and below are the upcoming MWK online talks. Retrenchment during the COVID-19 pandemic on 13 April 2020, and discussion on force majeure and frustration of contract in sale and purchase agreements and transaction on 15th of April 2020, and citizenship for adopted children and stateless individuals on 17th April 2020. Please visit our website at mawengkwai.com for more information, to read our articles, and to sign up for more upcoming talks. Next, allow me to introduce our speakers for today. Our first speaker for today is Puan Sarah Kembali. She's partner in our real estate practice group and Syariah estate planning. She has a Bachelor of Laws from International Islamic University of Malaysia and postgraduate diploma in Sharia law and practice from University Technology Mara, UITM. She was admitted to the Malaysian Bar in 2007. She's involved in real estate transactions and Sharia estate planning advice. Real estate transactions include drafting sale and purchase agreements, transfer of property during lifetime and death, drafting tenancy agreement, reassignment or discharge of property. The Sharia estate planning advice includes advising on drafting of Wasiat, preparation and execution of Hiba, understanding faraid, and Sarah is also a member of Selangor Bar Conveyancing Practice Committee and the Kuala Lumpur Bar Corporate and Conveyancing Committee. Our second speaker for today is Anis. She is an associate in our dispute resolution, employment, industrial relations, and individuals and families departments. She has a Bachelor of Laws from International Islamic University, Malaysia. She was admitted to the Malaysian Bar in 2018, and she's involved in advising on Sharia estate planning matters such as drafting wasiat and understanding faraid. Her areas of practice include general litigation, debt recovery, joint management body disputes, banking litigation, and intellectual property. All right, so this is our QR code for the Q&A session later. All you have to do is to post questions you would like to ask, and by scanning this QR code. I'll leave this here for a while so that you can scan the QR code. If you have any questions, please don't forget to post it up on this Slido website or in the chat, and we will address them at the end. So moving to today's talk points. Our talk points is what is a wasiat, what is the importance of having a wasiat, and the elements of a wasiat, and what is a hiba. So before we start, we would like to touch a bit on the COVID-19 MCO. Pursuant to the Section 11.2 of the Prevention and Control of Infectious Diseases Act 1988, PCID regulations 2020 was gazetted on 18 March 2020, and this is effective from 18 March 2020 to 31st March 2020, and then extended to 14 April 2020. The effect of this MCO is the restrictions of movements except for essential services. So right now, I will pass this to our first speaker of today, Puan Sarah. Okay, Sarah, it's all yours.
Thank you, Marcus. Good morning, everybody. I trust everyone has had their breakfast, and happy Good Friday to those who are celebrating Good Friday. Friday, Jumaat, is also the penghulu segala hari, the starting of every day for Muslims as well. So I'm pleased to be the first speaker for this wasiat session. I will be giving a talk on what is wasiat, the elements to it, and the importance to it. In addition to it, I will also be giving you a little slight faraid sharing, because faraid is a different kind of a topic that requires a whole 1 hour talk. It cannot be mashed together with this wasiat. My colleague, Ms. Anis, will be sharing on Hiba, which will be after my talk. without further ado, allow me to start off my share. So what is wasiat? In every single legal matter, we always would need to look into the definitions. So what is wasiat? We have to look into the Muslim Wills Selangor Enactment 1999 and also Syariah. Okay. Wasiat is an Islamic will, which means it's applicable to and for Muslims. The ones that actually do wasiat are the ones who are practicing the Muslim faith. Under Muslim Wills Selangor Enactment 1999, we'll call it the enactment, wasiat is defined in section 2 as an ikrar. Ikrar is usually known as admission or a promise made by a person, either written or orally or by gesture, stating he is under the obligation or liability to another person of some right. So this ikrar is made during the person's lifetime. And this ikrar is about the person's property, okay, and all the benefit thereof. And how is it carried out? For the purpose of charity or distribution, or any other ways permissible by the Islamic law. And these promises or admission is done after that person's demise. So in the Muslim Wills Selangor Enactment 1999, wasiat is those elements. Because of that, we shall follow what makes a wasiat effective from this definition. So next, we shall look into what is wasiat in Islam. In Islam, wasiat is a calling to write whatever that you have, not only write, just give in Surah Al-Baqarah. This is the first earliest surah whereby it says, it is prescribed when death approaches you, any of you, if he leaves any goods, that he make a bequest to parents and next of kin. This was the earlier part of the surah of Al-Quran. This means the importance of wasiat, to have property and devise them to your parents and next of kin. But later on, Surah An-Nisa, the surah in Quran, Surah An-Nisa, gives a division, which now we call it faraid. They have portions for each Quranic heirs. We call it Quranic heirs because these people are mentioned in Quran. So you do not need to put in any wasiat towards these persons because they have their portions. But also Surah Nisa in ayah 12 mentions that after payment of legacies, legacies means wasiat. You have to make the wasiat. So two things that are important after the payment of legacies and debts. So those are important in a person's life. Okay, in Hadith Sahih al-Bukhari, we're looking at this Allah Messenger Prophet Muhammad sallallahu alaihi wasallam. He mentions that it is not permissible for any Muslim who has something to will, basically something to give away, something to say, to stay for 2 nights without having his last will and testament written and kept ready with him. It's very important to note, even Prophet Muhammad says that you need to make a wasiat. So that it's very important to know that the property, the assets, anything that you own is distributed equally or however that it's supposed to be. Right? Hadith Sunnah al-Majah, Ibn Majah, also mentioned that whoever dies leaving a will, he dies on the right path and witness, and he dies forgiven. So this shows wasiat, a will, is important for our being. All right. So when you look, as I said just now, there's Quranic heirs. When you look into it, later on in Surah An-Nisa, there are portions and heirs that are mentioned. Yeah. So I mentioned faraid, so I will share a little bit on faraid, little bit, not much. Yeah, because like I said, faraid needs a whole hour or two to understand just the basic of it, then how to distribute it. So yeah, faraid is a distribution. Basically, faraid is a quantum, nisbah, portions for distribution towards the Quranic heirs, those that are mentioned in the Quran. Okay, where do you find these portions? It's actually in Surah An-Nisa, ayat 11, 12, and 176. Surah An-Nisa, ladies and gentlemen, is actually, Nisa means ladies. So it's a very interesting surah if you read it. Okay. Anyways, what are the Quranic heirs? Like I said, I mentioned Quranic heirs are those who are mentioned in the Quran. Okay. These are some of the examples in the Quranic heirs in there. Yeah. One is that the primary heirs, father, mother, husband or wife, daughter or son. Yeah. Secondary heirs, all those in there, the sides of the parents or the side of the mother or the father. Yeah. Substitute heirs is the grandfather, grandmother, and the granddaughter. Okay. All right. So examples of, before I go to this, I'll give you an example. Examples of faraid is, hold on now. The examples of faraid, for example, if a wife dies, leaving a husband and children, the children must be, if it's a son, for example, then the husband will receive 1/4 of the assets of the wife, because there's the son, and the son will receive the balance. This is one of the mentioning in faraid. Yeah. Okay. So, what is the importance of having a wasiat? Other than the fact that it is already mentioned in the Quran and the Sunnah about wasiat, that it is very important. It is a Sunnah, it is a way of living. Sunnah here, the Prophet ﷺ had carried on. Yeah. So what is the importance of having a wasiat? Is as follows. Yeah. Why would it be important? Because of this. Even though there is faraid, faraid is a way to distribute, but you need someone to be an executor, similar to executor. Without this executor, your assets will be frozen. Your assets will be frozen until you get letters of administration. Right? If you have a wasiat, you can get a grant of probate and you can start distributing according to faraid or according to whatever is in the wasiat. Next is to appoint a trustee. More that from the Quranic heirs that is not of 18 years of age. So you would need to appoint someone as a guardian and a trustee to these young beneficiaries or young Quranic heirs. Yeah? To identify what is Hiba. My colleague Ms. Anis will explain what is Hiba. But what is Hiba generally is gifts. So with mentioning it's in the Wasiat that this property in Petaling Jaya, for example, is Hiba to my mother. So it's already excluded. Maybe the transfer was being done and I pass away, I don't know, of COVID-19. No, touch wood. But yes, that's one of the ways. Yeah? You identify what are Hiba assets. Then you identify 1/3 assets to be distributed. In Wasiat, distribution of properties for a Muslim, according to Wasiat, you can only devise 1/3 of your assets to others, other than the ones that mentioned in the Quranic ayahs, right? Other than the ones in Quranic ayahs, or the ones in Quranic ayahs but was stopped from getting any portion. Okay, what do I mean by that? Let's say, okay, let's say we have husband and wife, mother, daughter, husband and wife, mother, grandmother, and son. Okay, grandmother, father side. Okay. Okay, the husband passed away, the wife gets the property, the son gets the property, the mother gets the property, but the grandmother doesn't. So that grandmother can still have something if you put it in the Wasiat. Okay. In Malaysia itself, there are situations where even though the main is 1/3, but there are situations where it's possible to devise more than 1/3. However, please be cautioned that this extra 1/3 can be challenged by the beneficiaries, the Quranic heirs. Yeah? Quranic heirs here means that the ones that are supposed to receive, they can challenge you, not you lah, basically they can challenge the Wasiat, and if they challenge it, the court has no recourse but to follow the faraid, and only 1/3 will be devised. Yeah? So other than that, Wasiat helps to avoid conflict between heirs. How does this help? Because that comes to my next point, complete asset of the heir list, by putting everyone inside the Wasiat, everything that you own in the Wasiat. One, you made it easier for the executor to do what is needed to be done. Two, the heirs know what is devised, what is given away. Yeah, and three, it's clear cut. Once it's there, it makes you more in control of the situation. Although you've moved on, but someone will be carrying out your wishes. Other than that, Wasiat is important for situations where there's joint property assets. This is husband and wife. In distributing assets or properties after death, even though there is a computation of faraid, the husband or the wife are entitled to joint property amount. Meaning that when they go to court for the grant of probate or the letters of administration, they can claim for joint property assets. Yeah? So usually the norm that I've read and the norm that we've seen, that in Malaysia, the joint property asset can be 50%. So what happens is if the husband dies, the wife can show proof that that was a joint property asset, in other words, harta sepencarian, then they can get 50%. Then on top of that, still get the faraid. So by putting it in the wasiat that this is a joint property asset, even though the name is not there, it's not registered the name of the wife or the name of the husband, it still is a property acquired during the lifetime of marriage. Yeah. So these are real life situations, some of it. Okay, married couple with no children, family with adopted or other children. Yeah, these are the people who would require a wasiat to be done. So married couple with no children, and maybe they have siblings or they have parents who are still alive. Yes, the parents would get the property, but the balance of it, it might just go to Baitul Mal, for example, or it might not be identified because we do not know due to no wasiat. Family with adopted or other child. Other child here means maybe a person who is your stepson or stepdaughter, or someone you are close to, yeah? Or your niece or your nephew that's not getting the inheritance from the Quranic heirs. So family who has the adopted child, especially, the adopted child does not inherit in the Quranic heirs. It's not in the computation of the faraid. They are not included because they are not blood ties. Yeah, so adopted child needs to be mentioned in the wasiat. Okay. Married couple with no son. Just now I said married couple with no children. So what happens with married couple with no son? Means all daughters. There might be situations where the person wants to devise the property to someone else. Yeah? So this needs a wasiat. Individuals who enter Islam with no other Muslim relatives. Okay, these are for those individuals who are mu'alaf, we call it mu'alaf, who enter into Islam, and they have a mother and father who's still a non-Muslim, be it a Buddhist, a Christian, or any other Hindu, any other religion. So wasiat would help the son or the daughter to devise the property to the non-Muslim parents or non-Muslim siblings. Yeah. Family with child under 18 years of age, a wasiat will have, or a trustee on how the distribution of money to be given to this child. Yeah. Okay, and then there are some properties that maybe you do not own entirely. It's actually put on trust or you're a nominee. So in a wasiat, you can mention this property is not your property. So it will be excluded. So that is also why wasiat is important. Child with adoptive or non-biological parent. This is for the child. Well, child here could be, it must be someone who's more than 18 years of age if you want to write a will, wasiat, a Muslim will. So the child can give their own wasiat towards their parents as well. Okay, right. For charity of choice, that could be any kind of charity of choice. Yeah. So these people are needed in a wasiat to show that they are the beneficiary. Again, 1/3 of the property. All right. So we go next to the what are the elements of a wasiat. Okay. Elements of the wasiat. We go towards the enactment. Just a quick reminder, the enactment here is Muslim Wills Selangor Enactment 1999. For your information, in Malaysia, Islamic matters, Syariah matters, Islamic law, is governed by the state. This means every single state, be it Selangor, Kuala Lumpur, Kelantan, Perak, Terengganu, all of the states in Malaysia will have their own Muslim wills. Yeah. So, I'm sorry. So you would want to know, how do you determine which state to use for the wasiat? Okay. That will be determined by your place of stay, Mastautin, they call it. Yeah. Mastautin, where you stay in the IC. Yeah. Or you can even do a wasiat on the deathbed. So wherever you are, you can decide on doing wasiat there. Okay, let's go on the elements of wasiat according to the enactment, Selangor will enactment. Right, section 3 in the Selangor wills, Muslim wills enactment mentions that a wasiat must be written, and it can be oral or in sign. Sign here means sign language. Oral or sign language, it must be witnessed by two competent witnesses. And these two competent witnesses under the Selangor wills, Selangor are to be a person who are of a good character, Muslim, male, two male witnesses, and they have to be adil and not prejudiced. Yeah. Okay. Next, section 4 mentions that a wasiat must be signed by the wasiat, means the testator, right? So that a testator must be 18 years of age. 18 years. Why? Because any asset. So mine and not stopped from administering their, a testator here must all who actually are having to face an illness that is very fatal. For example, this pandemic of COVID-19, you can still do a wasiat. What does this category, fatal disease or marad al-maut means? Marad al-maut is where the disease results in death. The disease causes fear of death in the patient's mind, and the disease possesses some external symptoms that showing the disease, the thing is severe, and the disease is suffered continuously for a period of less than 1 year. Give me 1 second. Sorry, yeah, my connection went off for a bit. Okay. All right, so back to what is marad al-maut. So why did I share with you about this? Is because people on a deathbed kind of situation can make a wasiat, so long as that person is of sound mind, and the property must be 1/3. That's all. It must be 1/3. Okay. So next, beneficiary. Okay. It can be those existing, means that that beneficiary is existing, but if they are not identified, if a beneficiary is not identified, they have to be in existence during the testator's death in order to inherit. And from a charity organization, not specifically identified who is the persons to receive, that kind of identification, right? So assets or properties is in section 9. Okay. It must be of transferable. It's a pusaka, harta pusaka, a property that's left behind by the deceased. It's transferable. Worth and value. Okay, it has worth and can be valued. Alright, and it is in existence, means things that I mentioned. It must not be something haram or maksiat. You have property that you do not know of its source, like, or you do know, let's say it's haram. You kind of know that it's from a Arab factory or something, alcohol factory, and this is haram in Islam. You can't be putting in money for businesses that are not halal in Islam. So what happens? So those investment profits, it is best to be given to the Baitul Mal for distribution. So anything that's haram, it must be turned into a good thing by giving it to a proper authority. So you can actually give a wasiat on that, right? Next, section 26 of 1. This one specifically mentions that limit of the asset is 1/3 of the net asset. After you minus off everything else, net asset of the amount that you are given, you're allowed to wasiat, 1/3 in total. It doesn't matter how many beneficiaries you have, but it must be 1/3 in total. Yeah, not 1/3, 1/3 in total. Yeah. However, like I've mentioned before, this 1/3 can be more if the beneficiaries, the Quranic heirs, the rightful heirs of the deceased is agreeable to the distribution. And the agreeing to the distribution is not upon signing of the wasiat. Yeah? It's not upon when you actually drafting it and you say, hey, look, I'm going to give your mother all the property. This is more than 1/3. All the property so she can administer it for you. But she's keeping it all for herself. You know, 1/3. But if you want to, the persons, like for example, the daughters and the son, can only agree to this after your death. Yeah? Meaning that even if you talk to them, you tell them about it, if they decide during court, when you're doing grant of probate, when you're taking the application of grant of probate, you decide to, they decide that, no, I don't agree, I want this to be according to faraid, then the situation is that the wasiat of the properties will not be followed. Yeah? Okay, so this is what I'm sharing with you. It's a typical, not typical, I'm sorry, but this is one of the examples of a wasiat, but this is a wasiat that has been put in the Selangor Muslim Will Enactment 1999. Yeah. Yeah. It's in second schedule, and it mentions all this. Yeah, this one you put in your name, your IC, but wasiat can be in any form, in any way, but this is one of the ways that was in the enactment. So it says last will, your name, your IC, your address, and then healthy and sound mind. This one, we will always mention about Islam, no God except Allah. No associate, and Prophet Muhammad is his slave and messenger. Yeah. So this is the whereby I ask you to be fearful of Allah, following His orders and His Sharia, the religion. So it's in there, yeah. It's always the start of it. Then the payment of the funeral. If you that in total to whoever you mention the name, okay, and the distribution of the residue among the successors, right? Here, like I said, it's a simple wasiat. It looks like a one-pager, which it is, but it can be varied, where you can mention among my successors, which is listed, okay, which is listed in the appendix of the wasiat. So you can name all those things. And then this is for the persons who are supposed to take over or take care, basically, a guardian for the infants. Okay, who is the infants and who is, okay, trustworthiness, good character, and sound judgment. Yeah. Then the witness, and yet where you would need the testator's signature be witnessed by the two witnesses in front. Yeah. All right. Okay. Next. Okay. Next, the next video will be by our Okay, thank you. Over to you, Anis.
Thank you, Sarah. So we know that there's a problem with the speaker's connection just now. We do apologize, but if you notice in the chat, we will be sending you some slides, and we will also be sharing you links as we go along, so you can refer to that if you need our assistance with anything. So thank you, Sarah, for the introduction and for informing us on what is wasiat. Before I begin, I wanted to say thank you once again for joining us. I hope everyone is well. And without further ado, let's go into what is Hiba. So Hiba, as Sarah explained, is to put it simply, is that it is a gift. But what is to be noted is to distinguish it from a will is that the gift is to take effect during your lifetime. So meaning when you want to transfer a property or give someone with something, then this takes effect immediately, and it does not occur only after your death. On the legality of Hiba, the scholars have Hiba there's no statutory provision on Hiba or an act which governs Hiba, nor is Hiba specifically mentioned in Al-Quran. But the legality of Hiba is derived by the authority which cited by the scholars is in Surah An-Nisa verse 4. So this verse is referring to the dowry which is required to be paid by the husbands before marriage. But as you can see here, it's been translated as gifts. So here it mentions gifts, and to show that the underlying characteristic of the gift is that it's to be given out of goodwill, without graciously, and without expecting anything in return. Specifically, Hiba is an ikrar of a person made during his lifetime, in which he voluntarily gives away his property to another in his lifetime without expecting anything in return. So what you take away from here is, first, it is during the lifetime, like I mentioned earlier, it is voluntary, and it is without expecting anything in return. Now, you may ask, what is the relevance of Hiba in the context of estate planning and in relation to wasiat? But before we go into the significance and importance of Hiba, for you to understand it, you must first understand the differences between wasiat and Hiba. So wasiat, it takes effect after death. It is limited to 1/3 of your property, and it may be revocable, meaning So long as before your death, you can revoke your will, and basically in general terms, it means you cancel the will that you've prepared earlier and you write a new one. And there's a requirement in Wasiat, which we didn't go into detail, which is that there's one of the general requirements of Hiba is that the general requirements of Wasiat is that you cannot give it to the legal heirs because their entitlement comes out of the succession. So as Sarah explained, succession and Wasiat are to be taken differently. So those who are entitled under faraid and the law of succession should not be recommended that they're not included in the Wasiat, because Wasiat should be for those who do not have an entitlement under the law of succession. Moving on to Hiba. Hiba takes effect immediately. So a simple example is when you buy someone a gift, you give the birthday present to your friend, so it takes effect immediately. It doesn't wait. Your friend does not have to wait for you to die for her to have that gift. And the property is not given. The property, basically whatever you want to choose to gift, whether it's your house, your car, or 1 ringgit or from 1,000,000 ringgit, it's not limited. You can give how much you want to whoever you want, but be sure you know what you're doing, because the next requirement of Hiba is that it is irrevocable. So if we use the example I gave earlier, when you give someone, say for example, you wanted to give someone 1,000,000 ringgit for their birthday, you cannot later on say, can I have a return of that 1,000,000 ringgit, because it's irrevocable. You've transferred the property to your friend and you cannot ask for it. And there's the next difference is that there's no limitation to the recipient. So you can give it to whoever you want, and there's no ruling that it cannot be given to the legal heirs. And for both, it's not a difference, but a shared characteristic is that it's given voluntarily. However, nowadays, there has come this term which we've call as conditional Hiba. It basically means a gift where you put a condition that it will only be transferred to the next person if a certain condition occurs. So this is, in that sense, it is become an exception to the general rule that Hiba is given without expecting anything in return. As soon as you give a condition, it means you've expected something in return. Because I mentioned earlier that there's no statute and it's not mentioned in the Quran, the application of this principle there's different applications of the principle, but generally it has become accepted. And we will see through the examples of conditions on how Hiba has to be accepted and why it is now very common these days for you to have a conditional Hiba, sorry. So one example, or before that, although that there are varying opinions on whether a conditional Hiba is accepted, most agree that although the condition may not be valid, the transfer of property still occurs. So for example, if I give a condition that you can only have this laptop if you help me with my homework, but so the scholars believe that the condition is not valid, but the transfer of property is valid. So if I give you the laptop and I intended to give it to you and the person receiving it understood it as a gift, then even if they don't they don't need to fulfill the requirement of doing the homework before they can get the gift, because it's considered that the condition is invalidated, but the gift is still valid. So there are, for each conditions, the jurists vary on whether it's accepted or not. But I have listed here the view of the majority, and I will try to explain on why they've accepted it or rejected it. So the first example of a condition is that it is to take effect after the donor's death. The majority agree that this does not fall under a conditional gift. It is not a valid condition because this is similar to a wasiat. So in these instances, the property will be governed under the laws of wasiat and not a gift. And the next condition is that the receiver can have the gift so long as they are alive. So the majority view is that what is being gifted here is not the property itself, but the benefit of using that property. So for example, a house, the benefit of a house is you live in that house, or a car. If you have a car, you are able to use that car and drive around in that car. So here, how the scholars have interpreted is that you are giving someone the benefit of using a car, benefit of using a house. And this example is common in terms of when parents, say for example, they have many properties, many cars, and they allow the children to use that car for as long as they live. And even though the kids might claim it's their car, but it remains the property of the parents. So here it's considering that the gift is giving the benefit itself and not the property. So it's not so the car itself is governed on the normal principles of property ownership, but the benefit is governed under a gift. Whereas the next example of a condition is that there is, before that, what is different from the first example is that the first example is based on death. So that means it depends on someone's death. Whereas in this second example, the stress here is that it is the life of the person who receives the gift. So for example, if a parent, if we use the same example and the parents gives the house or the car, but for some, by the will of God, the child dies before the parents, then the benefit goes back to the parents. So that's how this is used in real life. So the next condition is that the receiver will get a gift if they care for the donor. So this provides for the situations where there may be people who are not our relatives, who are our friends, or maybe just our neighbor, who feels like helping the next door elderly person and out of the goodwill of their hearts voluntarily, and they want to help that person. So they care for the person. So usually we've actually gotten a lot of questions on this in the past where they've asked, is it possible for someone to give them the property because that person unrelated to me has cared for me? So this is a situation where we say that because they cannot inherit your property through the law of succession, faraid, you must gift it to them during your lifetime and not wait till your death before you want to gift it to them. Another example of a condition that can be set for a gift is that you say that you want to give this gift, but you can only have it next month. So the majority have viewed that this is acceptable because there's no issue of there's no doubt on the transfer of ownership. It is only that it will just happen later. So there's no doubt, and this is accepted. This condition, if put on a gift, is accepted. Another example is that the gift is to be used for a year. So the jurors are actually split half and half, but it's generally accepted under the principles of borrowing and not a gift. So if you allow someone to use something for just a year, it's as if you're just borrowing, say for a book. So you're not gifting that book to someone. You are merely allowing them to borrow, and the ownership remains with you. So this will not be considered a gift, but the condition is allowed because it is acknowledged under the principles of borrowing. The next example is that a receiver can only receive the gift if a certain event occurs. So for example, you can say that you can have all this candy in the shop if there's a change in government, for example. So that one is something that it used to be impossibility, but now it's occurred. But generally this condition is not accepted because to wait on that uncertainty, that doubt of whether something is to happen or not happen, it's not accepted in Islam. Similar to how we do not accept interest and we do not accept gambling because of that uncertainty and putting your financial status and your well-being up in the air with no certainty whether you can get your money back. So on that basis, this condition is not allowed. Another example of a condition set when you gift a gift is what we normally see almost every day, is that where the gift is given as a reward. So for example, when you purchase something if you purchase something during a promotion period or even just an ordinary period, they may give you complimentary gifts. They say that they will give you complimentary gifts. So this is a form of conditional hiba, because you will only get that gift provided that you purchase something from their store. So that's to show you the example of how this conditional hiba has now been recognized in today's application in terms of property and estate management. So now we move on to the advantages of hiba. So when we get questions on wasiat and estate planning, the usual questions that we get is it possible for me to exclude part of my property from other people inheriting, for my children or parents inheriting my property? Or they may ask, is it possible to give someone more than a third of my property? Or they may also ask, is it possible to speed things up? Is it possible, because once you get a distribution order, it may take a while for everyone, especially in Islamic law of succession, meaning that they take a while to calculate, to identify all your assets. They take a while to calculate, and they take a while for you to find out who are the living heirs, because they need to, in terms of calculating the faraid, and in terms of calculating who is to succeed, who is to inherit under the laws of succession. They need to know who's alive, who's your relative, who's not your relative, whether you have any adopted children. So all of this takes time. So it is for these reasons that we always recommend, we will answer that question that no, you cannot exclude people from your distribution. You cannot give out more than a third of your property through a will, except you cannot do it by way of wasiat and faraid anyways, but you can do it through way of hibah. But this, for you to make sure that it is distributed according to how you like, it must be done during your lifetime. So the advantages of hibah here is that it will be excluded from the estate, harta pusaka. The heirs do not have a right to claim for what was given as hibah, because the hibah is considered that it is no longer your property, it is that person's property, and it will be up for that person to determine how he wants to have that property distributed, and he has his own heirs, so you cannot touch that. And also, because it's not part of your estate, there's no issue of, for example, if you had a separate agreement between all parties who are meant to agree, but later on this agreement must last until after the testator's death. So normally we do see situations where the siblings and whoever is to inherit will promise that they will distribute according to the will, but afterwards, when the person passes away, then suddenly all these challenges occur. So to protect that from happening, you gift a gift before your death, and that makes sure that the right person receives the right property. So in that sense, Hiba creates a greater freedom to distribute assets according to your wishes rather than under the law of succession, and it is not restricted to the requirements of a will. And moreover, the principle of Hiba is encouraged because it promotes Islamic values of giving, well, not Islamic values, but universal values of giving and love, and this is why you should consider distributing your property through gifts if you want it to be distributed the way that you wish, rather than relying on the law of succession and hiba, which may result in quite a few issues. I think I've reached the end of my portion. I hand it back over to the moderator, Marcus.
Thank you, Anis. So now it's the Q&A session for you all to pose questions to the speakers. So we will now take questions from Slido and from the chat. I will be sharing the Slido screen
I will see into some of the questions. First, there's one coming from the anonymous here. What are the additional condition requirements for writing a wasiat under the Sharia principles in addition to the provisions of the Wills Act 1959? All right. Here are the additional conditions. One is that Muslim. It must be a Muslim. It's a wasiat, so it must be a Muslim. Secondly, the properties that is being devised, bequeath, however you should call it, it has to be 1/3. 1/3. It's not everything you can give away. However, there's a subject to that. If in the event that it's more than 1/3, it has to be agreed upon by all the Quranic heirs upon the death, meaning that when you're taking grant of probate or you're doing letters of administration, that is the time when the Quranic heirs will confirm whether they are agreeable to this division of more than 1/3. So that is the most ketara lah, very out, the standing point of wasiat requirement. Other than that, the two witnesses, according to the Selangor, this is Selangor, again, I repeat, unlike the Wills Act, which is a federal matter, we have, every state has their own Sharia law. So in Selangor enactment and Selangor Evidence Act, the Sharia Evidence Act, the two witnesses shall be two male witnesses, and also they are to be two male or one male and two females. Yeah, that is in the Selangor Sharia Evidence Act. Yeah, that's one of it. So the anonymous number one. Then the second one, what are the key differences on estate duties or stamp duties payable upon distribution of assets under a conventional will and that under the Sharia principles? Well, to answer this question, as far as I know, estate duties are not applicable. Stamp duties is, but a nominal sum. And there's no differences between the conventional will and the Sharia, because the only difference in those two is that when you devise a property, it's 1/3. So that's the difference, and 1/3 of stamp duty. But nominal is 10 ringgit. So yeah. Okay, there's a question from Encik Shahab. Can you hibah to someone not related to you? This, I think, will need Anis to answer. Over to you.
Thank you, Sarah. So I see here there are a few questions on Hiba. Let me just go through it and try to reply to all of them. But so the first one is, can you hibah to someone not related to you? And the answer is yes. Just like when you give a gift, it doesn't matter if it's a Muslim, non-Muslim. Yeah, you can hibah to someone not related to you. You can hibah to a non-Muslim. In terms of what are the elements of hibah, it is basically there's someone who gives something, someone who's receiving it, the property, and there's actually there's no fixed or laid out elements of hibah because it's not provided in statute and it's not in the Quran. But if you just imagine a normal gift, when you want to give someone a birthday present, that's basically a hibah, a gift. But in terms of estate planning, obviously it goes more into that. It goes into the property, the house, and your savings. And let's see what else. So there's another question is, what's the equivalent to hibah for the non-Muslim? It's just translated as a gift. So when non-Muslims give gifts to each other, it's the same thing. There's no difference between a non-Muslim hibah and a Muslim hibah. It just means a gift. Sarah, do you want to take some questions as well? Others not related to hibah?
Sure. Okay. There's one after Encik Shahab that says, does daughter born out of marriage inherit from mother under faraid. Out of marriage, yes, inherit from mother, yes, but will not inherit from the father. Yeah, the mother can still, the mother's property still can be devised to that daughter because of the blood tie. Does inheritance tax also apply for Muslims? I am not so sure about inheritance tax because as far as I'm concerned, in Malaysia, inheritance tax is not applicable at the moment that I know of, yeah? Okay, does insurance payout become part of estate upon death? Okay, insurance, KWSP, insurance is, it depends. What I mean by depends is that what kind of insurance plan have you put in for yourself, right? So if it's an insurance plan whereby it works as though it's a gift, or rather it's from the start, it's already like a hiba, it's given. So it's considered given to the person that's in the beneficiary. However, there are insurance plans where even though you put in the nomination is the same as KWSP. People, Muslims who put in nominations for KWSP, those people who are in the KWSP nominations are not the beneficiaries. Yeah, they are actually the person who was supposed to be executing, or rather distributing the proceeds of KWSP and insurance for the faraid, the Quranic heirs. Yeah, all right. So hopefully there's one question here. Says, on your wasiat page just now, English is always okay, right? This could go to Sharia court later or other government body, and there is no need to supply a BM translation. Okay, for wasiat, it can be done in English. We had one case that we went to High Court. For your information, for a Muslim's wasiat to how do you say, to start it off lah, basically in layman's term, what you do next is actually you go to the High Court, civil High Court, yeah, civil High Court, not the Sharia High Court. Sharia High Court is to get the faraid, sijil faraid, okay, but for the grant of probate, the letters of administration, you go to the civil High Court. Yeah, so civil High Court, you can go there, and we had one case that was a probate matter. In other words, there was a wasiat. It was done in English. Yes, for example, I know the norm is that usually we get wasiat done in Malay, bahasa, or with all the Arabic words and things like that, but it can be done in other languages. When we did the wasiat for the will in English, we didn't have to supply a BM translation. Yeah. Okay. Another one is, can explain again section 7 on the specified and unspecified. Don't quite understand. Okay, section 7 here, if you go back to that particular section, is about the beneficiaries. Yeah. Give me one moment. Yeah. The condition of beneficiaries. So condition of beneficiaries here means that you must, it must, if it's a specified beneficiary, that beneficiary must be there. Meaning that if I specify Marcus, for example, in my wasiat, all right, that means Marcus must be there. He must be alive. He must be in existence. Okay. That's a specified beneficiary. Okay, when I die, he also must be there. Unspecified is, let's say, usually it's the case of charity, whereby you say things like, oh, I would like to give 1/3 of my property to the next masjid that comes up in this place or something like that. All right, something of that sort. It's unspecified. It's not specifically for a person or a government or a government body or a company or things like that. So it's not specified. So when it's not specified, it must be in existence when I die, so that you can devise the property. Yeah. If it's specified, it must be in existence when I'm around and when I die. Okay, that's what it means. Yeah, the beneficiary. What are the additional condition and requirements for writing a wasiat under the Sharia principle? In addition, I think that one already done. Wait, hold on now. Let me see if there's anything else. Okay, what if your fortune dwindle and you do not have 1/3 at that time? Yeah, death. Yes, you can mention that 1/3 of my properties at the time of death. You can mention that. It's not specified, but you can still list down all your properties in your wasiat. That's how it is. So 1/3 of the property means the net, the whole properties that you have. So that's why you need to list down. So even though I understand, sometimes we sell the property, we buy a new property, and tak sempat nak update the wasiat, yeah. But at the same time, if we do have some sort of wasiat that has all the list of properties, that will give a guidance to the executor to check one by one. And if there's new ones, the executor can add it on, because whatever it is 1/3 of your property. Yeah, I hope that's clear. Is there anything else? Marcus, can you see whether I've left anything else? Oh, I appreciate. Yeah, okay, go ahead.
There's a question here. Is conditional Hiba accepted in Malaysia? And what is the difference between conditional Hiba and declaracy Hiba? So conditional Hiba is accepted. It has been recognized in a few of our Syariah courts. But like I said, because there's no provision, the judges have exercised their own judgment, and generally it is accepted. In terms of declarasi Hiba, Sarah, have you faced anything? But from my understanding is that it refers to, because don't be mistaken that Hiba can also be included in the will, or it can be declared, because you will still need to have it on record that this property is Hiba to avoid any doubts in the future later. So, but you state that it's given as a gift and it's not subject to distribution according to succession.
Okay, I'm going to take one. I saw one in the chat. Okay, in the chat it says that as I asked above by Satish Ramachandran, I understand that one, the signature of the testator in a Sharia wasiat can only be witnessed by 2 witnesses, only by a Muslim person, non-Muslim cannot witness. Yes, that's correct, because that's in the Syariah Selangor Evidence Act. Yeah, it must be a Muslim. And 2, but non-Muslims may be beneficiaries of the 30% assets in the Sharia wasiat. Yes, that is correct too. Like I explained, sometimes some of these Muslims are mu'alaf. Mu'alaf here means those who just embraced Islam, and they have parents who are non-Muslims, or they have siblings who are non-Muslims who are still alive. They might just want to give it to them, which they can. It is possible up to 1/3. Even if it's more than 1/3, the other heirs, maybe the wife or the children, they're agreeable to give to the non-Muslim parents of the deceased. It's possible. Yeah, but it's upon death lah. Yeah, I hope that's the question is answered. And then there's one more. Is there a residual clause for wasiat for Muslim? I would say no. Basically, because 1/3 of the property means 1/3 of the property of the property of the deceased. Any residue will be distributed via faraid. Which also means, like I said, faraid is a long topic. The balance after faraid goes to Baitul Mal. Yeah, any balance, even the slightest 0.01% of it, 0.0001% of it goes to Baitul Mal. Yeah, all right. Hope that's clear. Anything else? Anis, Marcus, any questions that we might have overlooked?
I think that's the last question we have here.
Okay, just for everyone's information, I've written up an article on what is Wasiat in our MWKA website. Please do check it out. And there's an FAQ in the same article which you can click on. And that FAQ has the frequently asked questions that may or may not be in your mind about Wasiat. Yeah. Okay. Sorry, I saw two more. Okay. Just to respond this question, the balance of the property after faraid goes to Baitul Mal. Are assets of non-Muslim Malaysian Muslims treated similarly to the Malaysian Muslims? I think that one you would need to get the will talk. If we have one, we will update you on that. Okay, anything else? If not, Marcus, back to you.
Okay, all right. So thank you, Sarah and Anis, for your insights. So to our guests and participants, thank you for joining us today. We hope that you have found today's talk informative and useful. But before we conclude, I have a few announcements to make. The first one will be, we would like to invite you to join us for our upcoming talks. All right, so these are the topics for our upcoming talks. So the one we have next Monday on the 13th of April is the retrenchment during the COVID-19 pandemic by Diana and Janessa. And next one on Wednesday will be a discussion on force majeure and frustration of contract in SMPs and transaction. Will be myself and Sarah being the speakers. And on the 17th April 2020, will be a citizenship for adopted children and stateless individuals by Jasmine and Eric. So you can sign up at our website, maoinquiry.com, or go to the events tab on our website. And secondly, please fill in our feedback form. The link will be posted in the chat to tell us what you think and where we can improve. And thirdly, you can follow our social media accounts. The links will be posted in the chat as well. Okay, and lastly, we would like to, if you'd like to speak to our speakers, we offer a complimentary 30-minute consultation over the phone or video conference. Please fill in the form on our website. The link is posted in the chat box.